in Qatar Investment and Projects Development Holding Company and another versus Phoenix Ancient Art S.A. and others, the Court of Appeal granted the claimant's application for security for costs for their appeal, but reduced the quantum from £225,000 to £70,000. The appellants, a Swiss company and two individuals resident in Switzerland and New York, appealed against summary judgment granted by Justice Garnham following disclosure failures. The claimants applied for security under Rule 25.291, relying on three grounds under Rule 25.27. Residence abroad, Phoenix's inability to pay, and steps taken making enforcement difficult. The court found all three grounds established. It rejected the pre-Brexit rules argument, holding that the 2025 amendment rules applied. Phoenix was found to be insolvent based on adjusted accounts. The individual appellants had taken steps placing assets beyond reach, including disposing of interests for no consideration and making unexplained payments. Their property equity was precarious due to substantial local creditor claims. Ordering security was just and not discriminatory, given objectively justified enforcement concerns. However, the claimed costs were disproportionate for a one-day appeal, and costs related to the respondent's notice were excluded. Security was ordered at £70,000. Quote, added to that, the appellants have a history of failing to provide full disclosure of their assets, and of paying prior costs orders in these actions late, and only when necessary to enable the actions to continue. Accordingly, I consider that the amount of security ordered should be limited to an amount which reflects the claimant's costs of responding to the appeal, excluding the costs incurred in respect of their respondent's notice. I consider that a sum of £70,000 is a reasonable and proportionate level of costs to be incurred in responding to the appeal.
For a detailed summary of this decision, visit tmclegal.co.uk.